afternoon, everybody. My name is John Giardinelli, and I am Association Counsel. Today is John's Rants. We're going to talk about a couple of things. It's kind of a little mixed bag of things that have been happening lately. So I want to bring you current on a few things. Hopefully you'll find the information helpful. A lot of it comes from what the professional standards manager is getting in the way of calls and complaints. And I just want to kind of clear the air on a few things. So let's get started. Number one, I am recording this on March 24th. On March 25th, so probably by the time this is posted, N.A.R is going to make a policy statement on the issues relating to clear cooperation. So by the time you see this, we will finally have at least N.A.R's position on whether or not they're going to do away with clear cooperation. And if not, and spoiler alert, they're not, then they're going to advise on whatever policy changes they care to make. And we, of course, in a separate report, will let you know that once their position becomes official. So that's taking place right now. There was an issue that came up recently that I want to bring to your attention, and it has to do with the continuation policy, the continuation clause that is in the current version of the BRBC. The BRBC currently has a clause that makes perfect sense that says that the parties should elect what is referred to as a continuation period. This is a period of time that will commence either at the conclusion and termination of the agreement between the parties, or if the agreement is terminated prior to the original termination date, that says, hey, if let's just pick a number. Let's just assume that it's 45 days for the continuation policy. It can be longer, it can be shorter. It's up to the parties to negotiate. So let's say we've picked 45 days. So what will happen is this. 5 days prior to the termination of the agreement, or within 5 days after early termination, if someone cancels the agreement in accordance with its terms, the broker for that buyer is required to provide that buyer with a broker involved property list. Now there's a form for that, and you should provide that document to the prospective buyers / client in a timely manner, and list all the properties that you believe you were involved in. And when you do that, you will preserve whatever rights you might have to compensation if those parties purchase a property that is on your list. Now, there's a lot of issues which we'll talk about at a later time, but one of the issues that came up recently that was raised by a very, very fine broker at the association was, is that extension period in violation of the new law that says that contracts cannot be for longer than 90 days and 3 months actually, but the regulations will say 90 days. And the answer is it is not a violation. The new regulations, which should come out sometime in July, will say that the contract will commence on the day after the contract is signed, unless the parties agree to commence the work to be done later. Let's say, for example, the buyer wants to get some things resolved and then start searching, touring, etc. You can do that. That's going to be okay. But that if you show a property and the buyer does buy that property, but after your agreement has been terminated, that would not be a violation of the 3 month / 90 day rule, because you did perform, and it would be fair you satisfied the requirements of the law. So it is going to be very important for you to be able to prove, hey, I showed you this property. I was involved in defining this property for you, giving you information, touring it with you. In other words, going into the property, your instruction or your request, or with you, either virtually or in person. And I should be entitled to compensation. Then what will happen, hopefully, at least in theory, is if the new broker is aware or is made aware of your involvement, and hopefully buyers will understand that they should make that broker aware, and hopefully that broker will inquire, then it can be worked out. Do you believe you're entitled to the entire commission, maybe a referral fee? Whatever can be worked out, hopefully that will be something that can be negotiated, but at least you will have some rights to protect yourself and your potential commission. Because again, the theory being, both at the DRE and at CAR and under the Code of Ethics, is that, look, had it not been for me, you would not have been aware of the existence of that property. I showed it to you. I provided you with substantial information relative to this property. Therefore, I should earn some compensation. Another issue that's been coming up lately that I just want to clarify a couple of things on is this concept of liquidated damages, right? First of all, liquidated damages is a term that is much more comfortable in the construction field. And basically what it says is, look, it's going to be very difficult to establish whatever damages would exist if a party were to default, right? How do you measure damages in a construction dispute? Well, that kind of theory found its way into the purchase agreement. And it says, essentially, if the parties initial the liquidated damages provisions set forth in the residential purchase agreement, then the amount of the deposit will be the amount of damages that the seller will be able to retain as damages and will not have to prove damages. And frankly, if there is a default, the buyer will not be exposed to anything greater than that amount of deposit. Now, the law, if it is a residential property, requires that it be in writing, that the deposit in a residential 1 to 4 cannot be greater than 3% of the anticipated purchase price. So $1 million would be 3% of that amount. It can be less, but it cannot be more. That any amount greater than 3% is to be returned to the buyer, and that there has to be a default. So all the contingencies have been removed, and then the buyer is not able to close, or some other default. If the amount is less than the jurisdictional amount set by the legislature for small claims, you can go to small claims court and argue it. If it's greater than the amount allowed in small claims court, then you would first mediate and or arbitrate the dispute, and therefore you're going to be hiring lawyers. So it's clearly important that you understand, but the parties will basically agree in advance what their damages are going to be in the event that the buyer defaults in the transaction. And so even if the deposit is not made for some reason, there still can be a claim made if the proper paragraphs were signed. Now, what if the deposit is 1% at the beginning, but based on certain events, will go up to a different number, say 2%, or even up to the full 3%? There is a paragraph that you must initial, in the RPA for increased deposits, and there are forms for all of this. There's also a quick guide that CAR has for liquidated damages. So just go to the CAR site, type in quick guide, type in liquidated damages, and if you need to, you can get more information. Lori tells me that there's also some misunderstanding about mediation. So I'm going to just tell you what mediation is. First of all, mediation is provided for without election in most of the CAR contracts. It's provided for in the RLA, provided for the residential listing agreement, is provided for in the buyer broker representation agreement, and it is provided for in the RPA purchase agreement. It basically says that if either party fails to offer and or agree to mediation, and there is therefore litigation, the prevailing party who rejects mediation will not be entitled to their attorney's fees. Now, there are some exceptions to that. If you have to file a lawsuit quickly because of some other purpose, to get a lis pendens recorded, to beat a statute of limitations, but then you must offer mediation, and of course the mediation has to be acceptable. So what is mediation? Mediation is essentially a relatively expensive alternative dispute that says there doesn't have to be a winner, there doesn't have to be a loser. We are going to go to a professional mediator, and the association has those people available, although there are also professional mediation services available at a much, much higher cost. But that you will go to mediation. Someone, frankly, like me, will try and work out a settlement between the two of you to get the matter resolved, and success rates well over 80% across the board. So the case is going to get settled. It's therefore going to save all kinds of money for attorney's fees, time away from work, time preparing for dealing with all of the issues relating to discovery and other litigation issues. So mediation is to be done, does not require a lawyer. It's to be done before a unbiased third party trained mediation person. If you go to mediation and you do not settle, nothing that was said at the mediation can be used in court. The mediator cannot be called to testify, et cetera, et cetera. If the case is settled, it'll be reduced to a enforceable written agreement. And of course, neither party is obligated to come to a resolution. If the parties cannot agree on a settlement, then they will be free to either arbitrate or litigate their dispute. Again, no one can make you settle a case. Oftentimes, if it's a realtor involved in the mediation, the insurance company that covers that person will be available to provide either defense counsel or participate in any amount above the deductible limits of the policy. All right, well, that'll take care of it for this time. What we're going to be doing in the future is we're going to invite some guest speakers to come in and help me present some of these very complicated issues. The issues that are coming up are updating the code of ethics, updating procuring cause, updating some of the MLS rules, dealing with some new MLS products that I think are going to be helpful, the new regulations that will cover the new mandatory buyer broker representation agreement law, AB 2992. So there's a lot going on right now, and the association is absolutely dedicated to keeping you current on all of these issues. So keep an eye out for our next rant, which will be recorded sometime early next month. In the meantime, this is John Giardinelli signing off on behalf of the association. Thank you very, very much for your attention today.